I am welcoming Mark Chinn. He is a family law attorney in Jackson, Mississippi. He has been practicing for the last 40 years. He practices family law, and I'm not going to go over the awards and the accolades and the blah, blah, blah. It's too much. He is the real deal, though. He is no joke. He is an author. He has written 4 books for the ABA. One is on flat fees, and he is the person who started me using flat fees. All of this is because of this guy, Mark. So it is my absolute great honor to welcome Mark to this podcast. And the other reason that Mark is one of my idols is he has a lot of emotional intelligence. He's not just smart, he's not just wise. He certainly thinks like an attorney in a good way, but not in a bad way, not in an overcomplicated way. And he walks his talk. He's been married to the same woman, one woman, for a very long time. And he has 4 daughters. He's a good dad. They're well-rounded. He is the success story of the testament that you can be an attorney and still have a life that is worth living. So welcome, Mark. How are you?
Well, thank you. I really couldn't be better.
Awesome. And you started using flat fees a while ago. This is nothing new to you. Tell me how you started, what gave you the idea to start using flat fees, or that it was even possible, especially in family law?
Well, I don't know how this sounds, but I've always been more interested in the art of the practice of law than I have been in law itself.
What does that mean to you? What does that mean?
It means that I can look up cases. I can prepare for a trial by looking up cases and researching. I never, ever threw myself into memorizing cases and studying the law and writing law journal articles on the law. That has not been my focus. My focus has always been, how do I practice my craft in a way which delivers the highest level of service to people, and in a way which is highly efficient, and in a way which delivers service in a consistent manner. And how do I do it efficiently? I've been very interested in the art of the practice, and I've been interested in the art of service. I also have a background. My father was an engineer. I grew up working in hard jobs, working in a gas station, working in a steel factory. And through my training with my father and my training in working in these places, I saw the focus that industry has on being efficient, in making steps in the right order, making steps not twice, but only once, in creating systems and procedures which allow you to perform efficiently, effectively, and safely. That was sort of burned into my soul. And so as I threw myself into delivering systematic high level of customer service and a systematic high level of legal work from a how do I run my office standpoint, I started realizing that every step I took to become more efficient probably would lead to less income for me from an hourly billing standpoint. And I also saw, as I looked at my business and the income it was providing to me for what I was doing, that there was a mathematical ceiling on what I could make based upon the number of hours that I could work or the number of hours that associates and other staff members could work. It was mathematical. There's only so much you could make. And I wanted to break out of those ceilings. So I looked at all kinds of things. I studied how doctors charge. They charge for different procedures, and they're flat fees for certain procedures. And you'll see their list of things they check off on that cost you certain things. I thought, well, doctors do pretty well with that system. And so I looked at that. It just didn't quite seem to fit. And that's just an example of the many different things that I looked at, looking for ways to break through the mathematical ceiling. Sometime it must have been in around 2004, I saw a seminar put on by the Law Practice Management Division of the ABA on alternative billing, is what they called it. And as a part of the alternative billing seminar, they talked about value pricing, and they mentioned a author from California named Ron Baker and his book, Value Pricing. And that caught my eye. And so I got Ron Baker's book, which is about 600 pages.
No
Keep
joke.
in mind, I went through school reading only about 95 pages of any book that I was given, because I usually lost interest after 95 pages. But I read all of the 600 pages of Ron Baker's book, which walked you through the history of billing by lawyers, all the different stages that lawyer billing has been in, and how lawyer billing evolved into hourly billing. Then he goes into talking about how this is not a proper measure of the value of services, either for the lawyer or for the client.
Right.
And so through the process of reading this book and this experience of going through all 600 pages, I came to the conclusion that I needed to make the move. And then I did something which seems natural to me. I thought, I'm going to call Ron Baker. He may not talk to me. He's probably some kind of celebrity or something, but I called him. You know, who would think that a guy from Napa, California would want to talk to a lawyer in Jackson, Mississippi? But we talked for 2 hours.
I'm going to interrupt you for a second, because that's exactly how I felt about you. When I read your book, and you were, you're this ABA star, you're a rock star in the legal world. And I did the same thing. I had some questions, I had some fear, and I called you, never dreaming that you were going to call back. The next day, you called back. It's amazing what happens when you just ask. Sorry to interrupt you, but I wanted to get that in there.
Yeah, it is amazing what happens when you just ask. And there are some people that are not going to call you back, but a lot of people really are quite thrilled to share and pass on what they know to somebody who's interested. So I realized that it would take me a lot of study to figure out how I could charge from a value pricing standpoint. And I decided that the place for me to start would be to do a complete history of what I had charged people in the past. And so I had my bookkeeper. I've always had very good accounting systems. I think that's key to any successful business, and spent a lot of time and money on making sure I had a good bookkeeping system and good accountants. I asked her to run all of my cases for the last 10 years from top to bottom, the most expensive all the way down to the least expensive. And I grouped the cases from a cost standpoint and created about 5 different categories of expense. And then I started asking myself, why did that case cost what it cost? Why was that case expensive? Why was this case not expensive? Why did these cases settle? Why did these cases go to trial? Why was I able to do this one easy? Why did it move fast? And I came up with a lot of different criteria, all the ones that you can imagine. You know, who's the judge? Who is the attorney on the other side? What type of client did I have? What type of client was on the other side? What were the issues? How much was at stake? What were the personalities? And so I started trying to figure out if there were characteristics that led to very expensive or high conflict cases, and what were the characteristics of cases.
And it turns out there always are. You know, people think that it's impossible to predict. I hear that from attorneys all the time. I can't predict. You can't predict. I think that's a load of baloney. You can. It takes some work to dig in, but there's always a finite number of what ifs. And so this is the work. When people ask, how do I predict? This is how you predict, doing exactly what Mark's telling you to do.
Yeah, that's part of it. And I think the one of the major parts of it, from the standpoint of all those people who are concerned about getting caught in something much more significant than they realized, is the way you draft the scope of your contract. And we can certainly come back to that. But as I went through the process of moving from hourly billing to flat fees or value pricing, One of the places I really focused was value, because it occurred to me that I deliver more value probably in the first 10 minutes of the first interview than could ever possibly be quantified. I noticed you had something up on your Facebook yesterday about the mechanic or the engineer who came and looked at a ship that wasn't running, and he walked around for about 20 minutes, and then he tapped his hammer in one place, and suddenly the ship started running again. And his bill was $20,000. And they said, how can you charge us $20,000 for that? And he said, well, $2 for the hammer tap and $19,988 for the experience to know where to tap.
Right.
There's another story. I can't remember if it's supposed to be Picasso or some other painter, but somebody walks up to a street painter and says, well, how much is that painting? And he says, $1,500. And the person says, $1,500 for a little 5x7 painting. How long did it take you? And the answer was a lifetime. So what we bring to the table with the work we go through to get through law school, to get to law school, to get through law school, to in our training, to get to the point where we're advising someone is everything that is behind how we listen to people, how we counsel them. And it is not quantifiable in hours or minutes, in my opinion. It has nothing to do with what we delivered. This was a hard concept to figure how to mold it into representation when you spent your whole career, at that point, probably 25 years, billing by the hour. So I worked really hard on that. And I'll come back to that when I talk about my first experience. The next thing I had to decide was, am I going to offer this as an alternative, or am I going to jump in? I'm a big branding guy, and I think that, the way you brand yourself, the way you put yourself out there has one of the primary criteria has to be consistency. And, people have to know what you are. There shouldn't be confusion. And one of the ways to separate yourself from the couple 100,000 lawyers that there are in this country is to have a clear identity, a brand. And so the question to myself was, do I offer this as an alternative, or is this what I'm going to do? And I decided that it was not an alternative. I decided that I was going to charge this way. There also becomes a question, if you have associates, as I did at the time, are you going to allow associates to charge less than you to bring in that level of business? I also made the decision, no, my firm has a certain brand, whether it's me or my associates. And this is what I try to tell people when they talk to me about value pricing, that they're scared to do it. People have this thought that if they're going to do value pricing or fixed pricing, they have this thought that suddenly their whole practice is going to be changed. And if it doesn't work, they're going to be ruined. Right. That is, in my opinion, not at all the perspective that you should have. What I tell people is just look for the next case. Just look for a case to try it, and maybe try to pick a case where you think there's not much exposure to. Maybe pick an easy case where you just think there's not much exposure to problem, and then take the next case. I don't know if you have any questions about this stage of things, but I would like to go into talking about the first three cases I took.
Absolutely. What I will say about choosing whether to offer it as an alternative or not is, because I get that question a lot. And what I say is, if you believe that flat fees are best for your clients, which I 100% believe that flat fees are absolutely best for our clients for reasons that I don't know that we'll have time to get into today, then why would you offer hourly? If you believe that flat fees are best for your clients, why would you offer an alternative? But yeah, so tell me about your jump in the pool when you tried it out.
Well, the first case I took, the guy came to my office, and I don't know how this is going to sound, but I'll just tell the story.
You just tell the
story.
The
guy came to my office, and he had a pretty serious situation. He was a business executive. He was using cocaine. It was a relatively short marriage. The wife was threatening to ruin his career, but it was a relatively short marriage, and there wasn't a whole lot of money involved, but the stakes were really high for this guy. If the case wasn't handled in a pretty gingerly fashion, he ran the risk of losing his position and being embarrassed. When I got the case, when he came in, I said, "You don't need me. This is not a big case. I'm a battleship." What I said, "You need a PT boat." He says, No, I want you. And I said, "Well, there's not enough really involved to involve a battleship. You just need a PT boat." And, it's no, I want you. I said, "Well, okay, let me think." So I literally went home for an afternoon, and I said, "I'm going to just go home." And I sat on my couch. I got out my statistics on what makes a case hard. I started thinking about what brings value to people. And it came to me that the most important thing to this man was early resolution. Mm-hmm. Somebody had to find a magic key to get his case over with quickly. That was where the value lied to him. It wasn't in the amount of assets that were involved. It wasn't in the amount of money that he might spend. It was in the artistry of getting the case over with. There was the
value that I don't think many attorneys really think about a lot of the time. Getting a case done fast can be the thing, the value.
Well, yeah, you had something on your Facebook 2 days ago. Somebody said, "Well, I got the case done in half the time and the client wanted a refund. And how do I respond to them?" I didn't respond to that post. Somebody else did, but there is tremendous value in resolution. I've told countless clients to say, "Well, what would you do if you were in my situation?" I would say, I would go to my lawyer and I would say, "I will do anything. Get me out of this.
Yeah.
Just get me out of it so I can go back to my life and work in my magic instead of being drugged down by a legal problem for forever." And so there is tremendous value in early resolution. So I'll give you almost the exact facts of what I told the guy. I called him up. I said, "I've been thinking about this. Most important thing to you is to get this resolved as fast and as peacefully, as quietly as possible. Would you agree?" "Absolutely." And I said, "You have money. She's entitled to some money. This is my proposal. You give me $100,000. I'm going to put that in my trust account. I believe she's entitled to $65,000. Would you agree?" He said, "Well, yeah, it's a little high, but pretty close." I said, "Well, I think that'll be enough to incentivize her to end this case." And I said, "My fee is $25,000. I'm going to draft an agreement. I'm going to take it to opposing counsel personally, and I'm going to sit down with them. I'm going to say, here is a full agreement, and here is a check for $65,000 for your client. This is how I calculated it. This is what she's owed. No fight. She can have it today. No monthly payments. Here it is. Now, there's $100,000 in my account. If you don't take this money, it all goes to me to defend this case."
Brilliant.
The case settled within a week. And my client, to this day remains eternally grateful to me. So let's say I had, I don't remember, I kept track of my hours, but I don't remember what they were. But let's say my hours totaled about $10,000. So I made a premium on what might have been the billable hours, but that really wasn't anything that concerned my client. The thing that concerned my client was delivering the value that he needed, which was early resolution. And it was the incentive of the value pricing that allowed me to be imaginative and to come up with a plan that made sense and also would make sense to the opposition. The opposition knew I was paid. And so that brings tremendous power to any negotiation when the other side knows that you've already been paid handsomely up front. And that just brings tremendous power to any negotiation. There's no more, "Well, we'll drag this out and your client's going to see ever increasing bills." There's no more of that.
Yeah.
Say, "Knock yourself out. I've been paid."
Yeah. Well, let's talk a little bit about the different way to approach this mindset wise, because when you're using, I'm going to butcher what you normally say. When you're approaching it using hourly, it's about the process. Okay. Somebody hires me, here's the fee agreement, a week, I'll look through the questionnaire and then maybe set it for temporary hearing, then set it for mediation, blah, 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 blah. And that's not how you approach it. That's not the best way, certainly, when you're using flat fees. Can you talk about that a little bit?
Yeah, my line for that is that the hourly billing lawyer thinks in terms of what he can or she can do. The value pricing lawyer thinks in terms of what he can achieve.
Big difference.
I saw that put on your Facebook a couple of weeks ago, and it seemed like nobody got it.
No, I mean, it's a complete different shift, but this example is a perfect example of that difference.
Used to be, I'd get a $15,000 retainer and say, okay, I'll take your case on. No way for me to tell what it's going to cost. If I'm able to resolve it with, before the expenditure of $15,000, I'll return the balance to you. If it goes beyond that, I'll send you a monthly statement. And then say, okay, well, what do we do with this case? Well, let's file a lawsuit, see what happens, send some discovery, see what happens, then figure out where we're going. And that's fine, that's legitimate, but to me, it just seemed like it's a wandering, non-incentivized way of proceeding. I'm a mission-oriented guy. I mean, I run my life. Every move I make is based on first question: what's your mission? If I'm going to take a deposition, I write the mission for the deposition at the top of the questions before I start. What am I trying to achieve? Instead of what questions can I ask, my question is, what do I need to know? What am I trying to achieve? And so once you realize that before you can set a price, you have to know exactly what you're trying to do for the client and make sure that the mission is in sync between client and attorney. And so, of course, that's built into my contracts. But, so for example, client says, I don't want to go to trial. I just want to settle this. All right. So that then becomes the mission. How do we handle this case in a way that leads to resolution from a settlement standpoint? And then you write that into your contract. And then, based upon the value to the client, based upon time, based upon people on the other side, based upon whether you're going to go to a mediation, then you write the scope of your contract and you say, okay, I'm going to do this for 3 months for $15,000. Then I say, people say, well, what if the case isn't over in 3 months? I said, look, I'm putting the 3 months in there because I can't represent you forever.
Right.
I just got to put something in there. And if it's reasonable, if things are going slowly or whatever, I'll easily extend that. You got to trust me on that. We'll work together. So I kind of got off into scope on that, but
I want to go back to, because I get this a lot. It didn't happen when I was practicing family law. It didn't happen half as much as I thought it would, but it does happen when, fine, you're using flat fees. You have the incentive to get it done. The other side, the attorney, let's say, is a churner, I'm going to milk this case for every billable hour I can possibly get. And their client doesn't understand that. Their client's just, I guess, fine with getting another bill every month. So how do you handle those situations where it's pretty clear the attorney on the other side is just going to milk this for all it's worth?
Again, it lies in the scope. And if you know before you get into your case who's on the other side, then you build that into your price. Right. I mean, you just have to. Now, back when I charged by the hour, I concluded that the people who made the most money were the people who tried cases all the way to conclusion and got paid. But what I can remember from my days billing by the hour is the more the case started to cost, the more that bill started to go up, the more I got afraid that I was taking my client into an area of billing that they couldn't handle.
Right.
And so it was a real constriction on me, honestly, afraid if I was going to get paid, but also afraid that the client wouldn't feel good about the bill. And I'll tell you a little story about that. I took on a lady, and this is 30 years ago. We had a pretty tough case, and the case went on. I can't remember if it went to trial, but it ended up being a big bill, and she owed me, maybe $20,000 over the 15 that she had given me to start, something like that. And I called her up and I said, "Are you going to pay my bill?" And she said, "Mark Chinn, you knew how much money I had when you started."
I had a client tell me that once years ago.
I went, "You're right."
Yeah.
I did know. Yet I kept billing away and keeping track of all the hours in my firm the way you do, and thinking I was doing good, doing everything I could to help her, but I was obviously exceeding her budget. I knew that.
Right. And I mean, it's still her responsibility to pay, but the bottom line is,
these people, one of the things that happens once you are able to step out of the mentality of, is this case now costing more to me than if I had billed by the hour? Once you get out of thinking in terms of the hourly billing and thinking in terms of, am I getting killed on this case because I took too little? You get out of that and you stop thinking about that altogether. I've gotten involved in some cases just in the last couple of years that have just been ridiculous. They've just been ridiculous what the other side is doing. I'm in one right now. We're going into our 5th day of trial on Monday in a case that should have been tried in 2 days or less. The case should have been settled.
Right.
And the judge keeps telling us, why isn't this case settling? And it's because of the personalities on the other side. So I knew going in I had a tough case, so I obtained a very good fee. There's a very good chance that if I was billing by the hour, it would be more than what I got paid. But I don't think about that. I just get up and go and do my job. And I know that there's no pressure on me going to trial wondering if I'm going to get paid for it. I mean, I've already been paid. It's gone. I don't think about it anymore. The
it
place
really is
where,
true. I mean, you are so much happier. You're working less, you're making more money, you're more focused. You don't have all the things flying around your face like you do with hourly fees. You don't care. I mean, every once in a while, a case is going to be more than you anticipated, or, something's going to change. They're going to change opposing counsel or whatever. And at the end of the day, you really don't care. I promise. At least that's my experience. That's Mark's experience.
And you do have to count it as a learning experience.
Mm-hmm.
Maybe you're starting to see a trend, or maybe some of the cases you're taking are more litigious than you maybe thought they would be. So you maybe start changing the way you price. You certainly, and this is in Ron Baker's writings, you can certainly treat it like any building contractor and just write in change order provisions.
Right.
Where if things get out of line, you have the right to ask for a change order and additional funds. You can do that. And so you could say, this fee is good for, 2 days of trial, or, I've done that too. I've charged a fee for each day of trial. Now you can build in change orders for just if things get out of whack and everybody knows it's out of whack, like a couple of the cases I've had in the last couple of years. I have chosen not to do that.
Yeah, I didn't either.
I have chosen to say the responsibility is on me. I'm the lawyer. I know how these things go. The attractiveness of value pricing is you pay it, you know what it is, that's it. And it's on the lawyer after that. I think the integrity of sticking with what you said at the beginning is very important. And we all know how out of whack contracting prices can get on building projects, and the reputation of building contracts to be much more than you thought at the beginning. And I don't want that.
Right.
I don't want that reputation, because I want the brand to be, when I state a fee, that's what it is.
Yeah. And let's talk about some of there's so much fear associated with flat fees, which is always interesting to me because this is how we buy everything every single day. And attorneys just bring so much fear in the ethics. And I've done a whole podcast on ethics with an ethics attorney. The issues don't come up half as much as you think they are. In my opinion, there's always a workaround. There's always a way to do flat fees ethically and properly. What do you say to some of these fears and concerns that attorneys have about flat fees?
Well, I'm not sure exactly what question you're asking there,
Well,
but
let's
again,
one of them is, getting stuck in a case, which that's simple. You write it into your contract. You have timeframes. Getting stuck under pricing. I say treat this like a science experiment. You're going to make mistakes. You're a human being, and they're not critical. No one's going to die. You try it, see what works, and tweak, and move on. But attorneys are just so scared. And like you said, this is going to ruin my practice. And especially with the ethics. Well, you can't, I've even heard when I first started this in Texas and I had been in Washington, lots of people came out of the woodwork. You can't do that. That's unethical. And it scared me because I was new to Texas. And I'm like, what did I miss? What did I miss? I didn't miss anything. There was no ethical provision that you can't use flat fees or you can. And I talked to the bar. The exact quote was, that's absurd. That's ridiculous. Of course you can use flat fees. Of course. And, you have to do it in certain ways. And some states you can have earned upon receipt, some you can't. But there's such fear out there about ethics when most of the time the rules aren't even out there. When people are saying you can't do that, when you ask them, what are you talking about? They can't cite to an authority. Well, the bar doesn't like it. What are you talking about? The bar doesn't like it. There's either a rule, an ethics opinion, or there's not, right?
First, take a look at the statistics nationally on how many firms are actually charging flat fees. They will shock you now, the number of firms that are charging flat fees. But 20 years ago when I looked at this, 19 years ago when I looked at this, I thought, well, criminal defense attorneys charge by the flat fees.
Right.
Bankruptcy attorneys charge flat fees. Other attorneys in other parts of the state, usually the rural areas, charge a flat fee for a divorce. It may not be much, but they're charging flat fees. And in these rural areas, people can only pay so much,
Right.
So they get what somebody can pay and they do the job. And so for me, there was I started looking around, all right, who is charging flat fees? And it gave me a level of comfort that, yes, people are doing this. I might be the first one in the divorce scenario in my market doing it, but there are people doing it. And there are states where attorney's fees are an issue. It just so happens in my state, in the cases I work on, attorney's fees are almost never an issue because attorney's fees are only allowed if you can't afford to pay them. And almost always there's some assets or some loan that people can get where they can pay their bills. But if you're in a state where you have to put on proof of attorney's fees and it has to be by the hourly billing method, well, you just keep track of your time.
Right.
And, if you need that to get attorney's fees from the court, I understand that. So knowing that, I've built into my form contract a statement that says, if we obtain attorney's fees, first of all, I say getting attorney's fees from a court is very rare. But if we do get attorney's fees, there is a likelihood or a possibility that the actual fees awarded by the court will be less than what's charged. That is common, whether you charge by the hour or whether you charge flat fees.
Right.
They're almost never what you charge.
Never.
There are different ways to deal with these issues as they come up. I will say this, when I charged by the hour, I don't know how to quantify this, but I would have to say I had 10 times more complaints than I do charging flat fees.
Mm-hmm. Yeah.
I had a lady in the office the other day. She said, well, what am I getting for my money? And she said, how much have I used? And I was amazed because she knew it was a flat fee and it wasn't actually a very big flat fee, to be honest with you. And I said, well, it's kind of like a cruise. You pay for a cruise, you pay a certain amount, you use whatever you want to use, but that's the fee. And I said, I'll tell you what, I'll extend your cruise.
Well, in talking
well, this
about
doesn't feel like a cruise to me.
Exactly. Talking about getting attorney's fees, people are concerned about that. And my response to that is exactly like you said, first of all, my experience is you don't get attorney's fees when you're billing by the hour. Anyway, I didn't have trouble getting attorney's fees from the other side when I would have gotten them normally with flat fees. I remember in one courtroom in a small rural county when I was asking for fees and other financials, an audible gasp when the opposing party told the court what my flat fee was. And once I explained it to the court and explained what my client was getting, and she wasn't getting billed for me being there that day, including an hour late when opposing counsel was an hour late, wasn't being charged for the 3 letters that I had to write to opposing counsel for mandatory discovery. The judge got it and moved on. However, in Texas, there's it's a couple years old now, a case where the Supreme Court, I'm being careful not to disparage the Supreme Court, but essentially they said they want to see hourly if you're asking for fees, because how else would you be able to tell if a fee was reasonable, essentially was the gist. And I'm like, what are you talking about? You get paid, you're not getting paid hourly. How do we know whether your fee is reasonable, right? And I think that over time, the culture will change, but you're all over the country. I mean, you practice in Mississippi, but you travel all over the country. Have you run into that with judges that are just don't get it at all?
Yes. I have a lot of friends in Florida, and they tell me that the standard there is hourly billing. And in Mississippi, you're supposed to put the date of the service, the length of the service, and the fee. You're supposed to do that. A couple of points have come to my mind as you were talking. These 2 or 3 protracted cases that I've experienced in the last couple of years, there's a couple of things about what happened in those cases from a fee standpoint that I want to tell you. Number one is, in one case, the attorney's fees on the other side were 2.5 times what mine were, but they didn't get paid. Okay.
Right.
All right. And number 2 is when I saw their bills, which were horrendous, but they were hourly fee bills. When I looked at them, I might as well have been looking at Chinese. How could anyone tell if a bill is reasonable when you look at, telephone conference client, receipt and review letter, how do you know that's reasonable? In my opinion, at least half of what they did was unnecessary. But how do you prove that? They say they did it. They say this is how long they took. You don't know how long they took. What are you going to say? You took 4 hours to draft this complaint and I could have done it in 10 minutes?
Right.
How do you make those judgments? So I think this concept that somehow hourly billing creates a tangible measurement of what an attorney's done is ridiculous.
Yeah.
I long ago gave up trying to cross-examine an attorney about his fees. I mean, I tried it once and it was horrible. I mean, you're questioning an attorney about how much time they spent, or why did you have your associate look at this? You're not allowed to do that, and blah, blah, blah. It doesn't really get anywhere.
No.
It's all a matter of feel to the judge, probably, whether or not that's too high or not.
Right. A judge who may not have ever been in private practice, may not have ever drafted a complaint.
We won't comment.
We won't go there. But, when I think that, especially with talking about the bar and the legal culture, if the bar's purpose is really to protect clients, protect consumers, which it seems that most think that is their primary objective, which is fine. I don't see any argument that flat fees doesn't do that 10,000 times better than hourly. Like if you're serious about protecting clients, then you should be encouraging flat fees.
I 100% agree with you. Now, if you sent your daughter to the car maintenance shop and they said, well, just leave it here and we'll do whatever we need to do. And then she picks it up the next day and the bill's $1,600. Who wants to do that?
Right.
No, you go to the car mechanic and you say, What do you think needs to be done? What's your charge for that? And so you agree to that before you get started. And then they call you up and say, well, look, Mr. Chinn, I just found out, well, this belt's busted. It probably needs to be fixed too. It's going to be a couple $100. Is that okay? You go, yeah. But nobody is going to turn somebody like that loose just to build them whatever they want. And so why should it, it's an absolute disservice, I think, to think that attorneys should do differently.
Well, and I've been on the receiving end. I had to hire an attorney when my father passed away who charged by the hour. It was a small rural area. There were 2 attorneys who did the work, and only one called me back. And I practiced estate planning. I knew what she should be doing. I knew how long it should take. Her fee was reasonable. And I could evaluate whether it was reasonable or not, which our clients can't, by the way. I cannot tell you the spike in anxiety that I had every time I got a bill from her. And it didn't ruin my day or ruin my life or anything like that, but it was just that I didn't need. I was already going through a lot, and it was just this and compound that when you have a situation where it's a highly emotional case, your clients don't need that. I knew that the bill wasn't going to be more than like $4,000. And I would have absolutely rather have paid her 6 than the 3 I ended up paying her to never get a bill. Absolutely. One of the things that I discovered when I started using flat fees that was a surprise to me was that I did a better job. I considered myself to be a good attorney. I really cared about my clients. Tenacious. And when I started using flat fees, I was a better attorney. I was calmer and I was more focused. And that's what I think I chalk it up to is I was just far more focused. Can you talk about your experience with that?
Absolutely. Of course, we've talked about a mission-oriented approach that you have to follow in flat fees. Well, I'll tell you a short story. Not too long after I started doing this, a client called. They came in. They had been sued, and there was a trial set. And it's something in Mississippi we call Rule 81. You can set a case such as a modification or a contempt or something like that. You can set it for trial when you file the lawsuit. You can get a date for the trial, and there's no 30-day answer. It's just you've got a date for trial, and there's no need to answer. You can go or not go. And usually there's a continuance if an attorney can't be prepared in time. So this guy comes in, there's this Rule 81 trial set in like 3 weeks. And I looked at the whole case and I said, I can go win this case without discovery. I've got enough to win the case without discovery. I don't need any time. He has brought in all that I need to win the case. And I took it down to and I got a nice fee. I took it down to my associate and I said, here's the case. It's set for March 28th. I want you to go try it. She says, well, the first thing I need to do is get a continuance. I said, no. Well, I've got to do all this discovery. I've got to do all these things to get ready. Blah, blah, blah. I said, no, you don't. Go try. When she was so angry, I had to take the case from her because her mentality was, I got to do all these things. I need time. I need to push this off because I don't want the urgency. I crave the urgency. I crave it. There's nothing more exciting to me than getting a project in that I have to jump on and can try and get done. I mean, I absolutely love that.
Get it done and get it done.
Most attorneys shuffle paper from one side of their desk to the other and charge for it and think they're doing something. Right. But they're not actually. I'm not running attorneys down. But right. Let's just say I'm talking about.
We're being honest with ourselves. And attorneys, we lie to ourselves all the time.
Let's just say I'm talking about me back when I charged by the hour. And another thing I noticed, there was this gravitation in running up hours to cases that you knew you weren't going to get paid in. That always amazed me, that we would run up hours on cases we knew we weren't going to get paid in. And probably the reason was nobody was going to complain. the client wasn't going to complain because they weren't going to pay anyway. And so you run up the hours, trying to build your billables. And
Right.
Once you get out of that mentality of I've got to work more to make more, your whole mindset changed. And let's bring up a very important point here. Oh, I got to tell you the story about the second case. So the
Yes.
second case that came in was a farmer, very well-to-do farmer up in the Delta. He had a plan for, he was going to settle his case in this way. And I thought to myself, I don't think that's going to work. But then I thought, don't tell him anything. I said, what do you want me to do? He said, I figure you draft me up an agreement. I'll give you what I want in it, and I'll take it to her and get her to sign it. I said, what do you want to pay? He said, I reckon $5,000. I thought to myself, I can draft an agreement for $5,000. And he said, don't worry about it. If it gets out of whack, I'll pay you more. I said, okay. He said,
Like, yeah, you will.
He said, you can trust me. I said, okay. So I draft the agreement. By golly, he gets it signed. And my associate drove up to the court in North Mississippi with him to get it entered because he apparently had to appear in person. And driving back, he said, don't worry, I'm not going to tell people how little Chinn charged me. Well, I was keeping track of my time. It was $1,800 and I had made $5,000.
Right.
So that is one tool that comes out of that story. Ask somebody how much they want to pay.
I have never done that.
I say, what do you have in mind that you want to pay for this? And they go, well, I don't know. And I say, well, yeah, you probably do. I said, whenever I go into something, I always kind of got an idea what I'm willing to pay. Don't you have a thought on what you think you want to allocate to this? And a lot of times you'll get very good information about what the value is to them. And then you have to decide if it's something that makes you want to jump up and cheer. So
right.
You can get information from the clients if you just ask them, what do you want to pay? Like I asked the farmer, what do you want to pay?
And what have flat fees done for your practice? Not just the money, but as far as simplifying things, as far as time in the office for you, staff, what other benefits have you gotten from flat fees other than making more money?
Well, I remember I had an associate that just insisted on working until midnight the day before a trial. And I would say, why are you doing this? And she said, well, it's very important. I have to get ready for tomorrow. I said, well, if you need the 5 extra hours today, why don't you just put them in last week? Why do you have to work till midnight? And I believe it's the hourly billing mentality. It's the mentality of I've got to work hours to get the job done, instead of thinking in terms of what do I need to accomplish to get the job done. Not what do I need to do, but what do I need to accomplish to get the job done. And so I can remember sitting at home when I charged by the hour on a Saturday morning thinking, here I am sitting here doing nothing. I'm enjoying my Saturday. Maybe, I could go make some more money for my family if I went to work. I actually did that on some Sunday mornings.
So tell me the daughter story.
Oh.
I want to say Courtney, but it might not have been Courtney.
It was Courtney.
Okay.
Courtney is my 38-year-old daughter who now owns a furniture design store across the street, doing very well. But Courtney was about 13 and running track, junior high track. And track meets start at 11 or 12, and they go all afternoon. And Courtney ran the 800, or the 300 hurdles, one or the other, that was like the first race. So it was at noon. And a friend of mine that I did a lot of business with said, Mark, you need to go to Courtney's track meet. And I said, well, no, I don't. He said, well, yeah, you do. And I said, no, I don't. My job is to sit here and make money, support my family, like my dad did. And he said, no, you need to go watch your daughter run track. So I went and watched Courtney run. And of course, there's nothing better than watching your kid play a sport or do some music or perform. That sold me. And what I realized was you have to set aside time to do those things. Otherwise, life loses its luster. You're turning yourself. I think there's a martyr syndrome among lawyers.
Yeah.
And I actually will confess on myself that in the earlier years of my career, I used to think that I had to work until I got sick, because my mentality was, if I'm still healthy, there's still something left to give. I need to give some more. I need to work until I'm sick. That's wacko thinking. It probably comes from some of the sports indoctrination and some of the indoctrination I had from music directors who make you work hard or make you work through pain. But
we got it in law school too. We got it in law school that you have to work hard and you have to work long hours, and it's killing us, quite frankly. I had one colleague in Seattle who was a bigwig up there, the family law attorney in town, who would, go on vacation and still bill 10 hours a day. And I talk about this in my book. She was diagnosed with a brain tumor. And I've never known anyone diagnosed with a brain tumor who was around a year later. And so she had a finite time. Shortly after I found out she had been diagnosed, I went to a CLE. There she is presenting. You have a very limited time. And this is she was still in the literally work till you die. It's insane. And it is so in our culture. You're not a good attorney if you're not working 80 hours a week, which is insane.
Of course, there's this old story about the young man and the old man chopping wood, and the young man went furiously at chopping the wood, and the old man would chop a little bit and then sit down and sharpen his axe. And the young man kept going feverishly, and the old man would sit down and sharpen his axe. And of course, the young man petered out and couldn't finish because his axe was dull, and the old man finished the job easily because he had taken the time to make sure that his equipment was in proper shape and that he was in proper shape. And I think that I read a book some years ago, and it talked about, instead of managing your time, managing your energy. And it said that what you really bring to the table is not your time and effort, but your energy, to manage that properly. And I've also received some coaching where you take a look at, when am I most effective? When am I really on? And when am I not? So if you bill flat fees, you can really focus on that. You can say, I know I'm no good on Monday morning. All right. I know I'm no good on Friday afternoon. That's why we're doing this Friday morning. I know I'm no good on Friday afternoon. I know I'm no good first thing in the morning. And I know I'm really no good right after lunch. And so I started setting up scheduling rules, which brought clients in at times where I knew I would be high functioning. So, for example, my scheduling rules are nothing on Monday morning. That's my get it together, my plan time, look at the week, think about what I want to accomplish in the week. Nothing before 1:30. That's because I got to give myself time to get back from lunch. The last thing I want to do is be late for an appointment. So I schedule clients at 1:30. Nothing back to back. As I was looking at my day with a coach many, many years ago, I realized that I was scheduling things one after another. And the coach said, well, how does that make you feel? I said, well, I'm exhausted and I'm really not ready for the second appointment, because, each appointment with a client is like a final exam, really. If you think about,
your brain needs time to settle.
All you have to bring to the fore to counsel someone properly, the history of their case, the particular facts, the law applicable, the procedure that's been followed, the procedure that's to come. If you go back to back to back, you're just not ready. And then you get drained. And so I started looking at those things. I try not to schedule trials on a Monday. Sometimes you have to. I'm doing one this Monday, had to. But if you look at your peak times when you can really go, then you structure your schedule around that. When you're billing by the hour, your mentality is, well, it doesn't matter if you're in peak time. You gotta be there writing down those hours. Start at 8 o'clock and don't finish. And I can remember being at 5, 6 o'clock and just being kind of like this and thinking, I'm just running out of gas. But if I just push it through a little longer, I'll get into my energy around 7 or 8 and go till 8:30 or so and make some more hours. But truth be known, so I started to look at that too. And I said, well, okay. And through some coaching, I decided, and this is not anything mystical. I said, I started out each day writing down the time I was going to leave, because I have found that the task expands to the time allotted.
Amen. And I tell that to attorneys all the time. Part of what I teach is time management tools. And I like that energy management. I start using that. But we all have a great example of when we have had too much work to do in too short of a time period, and yet we've gotten it done. And that's the bar exam. You know, if you had unlimited time to do the bar exam, it would take you what, a couple months, maybe a year, maybe more, right? None of us did. We had 2.5 days. And the fact that we're all here with bar numbers tells me you got it done. Give yourself a time limit for a task. This task, I'm only allotting this much time. And guess what? You'll get it done.
I believe the book that I'm talking about is called The Power of Full Engagement.
The Power of Full Engagement. I'm going to have to write that down.
I believe that's it. It's been a while since I read it. It's a very, very meaningful book in my structuring of my career.
One last thing that I want to touch on briefly is one of the things that I have been admired about you is that you are not afraid to learn. You are not afraid to seek help. You use coaching. You read the books, and not only read them, but then implement them. And so many attorneys are scared to spend the time and scared to spend the money. Oh, I tried coaching once and it didn't work, so I'll never do it again. Tell me a little bit about your experience of what you've gotten back from reading the books and implementing, coaching, going to different groups. Not just practice management, but personal development as well.
Well, my thought was, if this is what I'm going to do, if this is my place in life, I've got to do everything I can to try and function at the highest level. I've got to seek out every bit of aid, every bit of instruction, every bit of help I possibly can, because this is me. There's nobody else going to do it. And so how do I get myself to the place where I'm functioning and living at peak capacity? The first thing I did was I decided to join the American Bar Association. And this is like 1989. I had just started my own practice. I was doing pretty good, but it occurred to me, I'm sitting here practicing law. How do I know that I'm performing at a standard of care? And I thought, well, I've been trained, I've done some practice, but how do I know that the people in New Jersey aren't 10 times as good as me? And so I decided to join the American Bar Association, and I joined the family law section. And I went to a meeting, and I immediately concluded I have to go to every meeting, or the affiliations, the associations, the friendships that I'm developing they'll go away. They'll be lost. So I committed to doing that. And it was not a bad gig either. I can go to a nice place from a Wednesday through to a Saturday, place that I would not normally go to. I've been to almost every city in the country through the ABA. And so I would go to and take their CLE, magnificent CLE. And what I thought was, oh my gosh, I'm gonna learn a lot. And what I found was 9 times out of 10, everything they were saying, I already knew. Now, does that mean it's a waste of time? No, it means I'm confirming that I'm okay. All right. So that's really important. Then there was 10% I didn't know. I go, whoa, I never heard of that.
Which can move the dial, move the needle big time.
It can close a gap in your malpractice for sure.
Well, there's that too.
And then another thing that I did, and this was a marvelous experience. They have these like 8-person round coffee tables in the meeting room, where people would go to get coffee and maybe buy some books or whatever. And you would sit at these tables and drink coffee and say, well, where are you from? What do you do? How do you run your practice? What do you charge? What's your retainer? What do you do with this? And you start learning from people around the country. And I love to tell this story. I met a lady from New Mexico who seemed to have a marvelous practice. And I said, what's your secret? And she said, I doubled my fees. I said, you're kidding me. You increased business by doubling your fees. So I tripled my retainer. My retainer is much higher than anybody else's. I said, okay, wait a minute. This doesn't make sense to me. You increased your fees 3 times more than anybody else and your business has gone up. I said, yep. I said, I don't think I can do it. She said, you can do it. And so I did it. And, I used to charge like, this is, golly, when is this? 1998, maybe. I used to charge like $5,000 retainer. So I said, okay, $15,000 retainer. And so the first guy came into my office to see me, and it came to that moment, and it was like choking in the back of my throat. And I finally just got out. I said, my retainer is $15,000. He goes, I expected that.
Right.
Anyway, so the ABA, and then I got into coaching. I got individual coaching from a group called Atticus out of Orlando, Florida. I've recommended them to you and to 1,000 other people. And I had a personal coach, and I decided I liked the idea of coaching. And so at one time I had like 3 coaches. There's an expense there, but I tell people Tiger Woods played golf better than anybody in the world. I bet he's got a swing coach, a putting coach, a fitness coach, a flexibility coach. I bet he's got coaches for everything. He knows how to do it better than anybody in the world, yet he still has coaches. And one of the reasons is coaches hold up a mirror.
Yeah.
A great coach holds up a mirror because you can't see yourself.
That's why they call it blind spots. You can't.
You cannot, I do yoga almost every day, and the instructor, I can't tell if my feet are positioned properly, but she can. She'll walk over and kick me and say, straighten your foot out, Mark.
I'll tell you, I used to do trapeze. Our brains are amazing at lying to us. And I would do a trick, and I would have sworn under penalty of perjury that my legs were straight, they were together. Absolutely. Well, then they, play back the tape, and my legs are like, it was just go. You don't see what you don't see. I know we're running long. I want to ask one more question, because I get this a lot from attorneys, is they are so hesitant to charge money for their services. They feel guilty about taking money from people, especially people who, quote, don't have it, which is an assumption on their part. Have you ever felt that? And what would you say to attorneys who, when we talk about flat fees and we talk about some of the numbers, they assume we're just money grubbing attorneys, I guess. I don't know. But what do you say to that?
The owner always operates on a fear of losing business. And back in the early days when I started charging flat fees, I had a young associate who was quite apt at this. I mean, he got it. So I would have what we call a pricing committee meeting, and I would call him in and say, okay, this is the situation. This is the fee I'm thinking about charging. And he would always triple it. I go, you're kidding. He goes, no, take it. And it always worked. I mean, I was always on the low side because I'm the owner. And I had a guy come in the other day. I charge $1,500 for an assessment, not for what we call an initial consultation. It's an assessment. In that time, I assess your case. And that is a very significant time. And I charge $1,500 for it. And a lot of people say, I don't want to pay that just for a visit. And we try to explain to him what takes place. And I had a guy come in the other day and he said, well, $1,500 struck me as kind of high, but I figured if you can charge $1,500, you must really know what you're doing.
Oh, and by the way, he does, and he brings it. You can't charge $1,500 for a meet and greet. Oh, Mark, I could talk to you for hours, and we'll do this again, but I want to thank you so much. You have been a leader for attorneys. You are touching lives that you will never know that you touched. And I just want to thank you for doing what you do. And I will put the links to Mark's website and his books If you practice family law, I don't know if you do practice family law without knowing and reading his books properly, but and his Dump the Billable Hour. I will put it in the comments. So thank you so much.
I've enjoyed it. Thank you.